Aaron Klein wasn't responsible for doxing the lesbian couple that had filed a consumer complaint against him for not making a cake for a same-sex wedding ceremony, how did that information get out into the public realm? Who was responsible for putting out this supposedly private information, which is now part of a public record, for the benefit of media sources, thereby creating the inevitable acrimonious debate in social media that led to admittedly horrible things being said to this couple? Who was responsible for this? It was the Oregon Department of Justice. I'm citing now from page 16, beginning at line 8, in the Bureau of Labor and Industry's final ruling on this subject. On February 12th of 2013, DOJ, that's the Oregon Department of Justice, emailed a copy of Laurel's Department of Justice consumer complaint to a number of media sources along with a note stating, "Hey everyone, please pardon the mob email, but it seems the most efficient and fair thing to do. Attached is the initial Sweetcakes complaint as well as the newly received response from the bakery owner's lawyer." That complaint once again contained Laurel Bowman's name, her phone number, her address, and her email address. That's the information that was provided to the public that supposedly constituted the act of doxing the couple, according to the social justice warriors. This is the Department of Justice taking a public record and giving it to the media. That's not something Aaron Klein did. After Laurel's Department of Justice complaint was publicized in the media, I will repeat that phrase. After Laurel's Department of Justice complaint was publicized in the media because the Department of Justice had given it to the media, complainants both had negative confrontations from relatives who learned about their complaint against respondents through the media. In January 2013, Laurel had just begun to reestablish a relationship with an aunt who had physically and emotionally abused her as a child and also owned all of the family property. Her family background must be gothic. Shortly after Laurel's complaint became public, the aunt insisted through social media that Laurel drop the complaint. She also called Laurel and told her that she was not welcome on family property and she would shoot her in the face if she ever set foot on the family's property in Ireland or the United States. This threat devastated Laurel, as it meant she could not visit her mother or grandmother, both of whom lived on family property. Rachel's sister, who believed that homosexuals should not be allowed to get married, wrote a Facebook message to the Kleins to tell them that she supported them. This was a crushing blow to Rachel, and it hurt her and made her very angry at her sister. Once again, what did the Kleins do to precipitate any of this? They received a complaint. They publicized the complaint. At this point, they weren't really taking an active public posture seeking support, and they would need support and as much financial aid as they could get to deal with this spiteful, petty, vindictive, spurious consumer complaint against them. All they had done was they had taken a public record and made a brief mention of it on their Facebook page. All these other things have nothing to do with anything the Kleins did. Scrolling down to page 18 of this final order from the BOLI, starting at line 21, complainants were legally married by signing a legal document of marriage in 2014, a few days after Oregon's ban on same-sex marriage was struck down in federal court. From February 1st, 2013 until the time of the hearing, many people have made hate-filled comments through social media and in the comment sections of various websites that were supportive of respondents and critical of or threatening to complainants. There's no allegation, once again, that Aaron Klein or Melissa Klein had anything to do with any of this. They never, as far as the record reflects, said anything hateful or spiteful or derogatory toward that couple. They simply said we're being sued, in essence. This isn't really a civil court proceeding because the BOLI is not a court. They said, in essence, we're being sued because of something that we didn't do. These comments, continues the final order, and the media attention was generated once again by the Department of Justice of the state of Oregon, caused Rachel stress, anger, pain, frustration, suffering, torture, shame, humiliation, degradation, fear that she would be harassed at home because the Department of Justice complaint with complainant's home address had been posted on Facebook and the feeling that her reputation was being destroyed. That's an awfully specific diagnosis to say that it was the act of posting this on Facebook that caused all of these symptoms. That post was seen by 17 people to begin with. Perhaps it propagated a couple of generations beyond that. But that complaint contained publicly available documents that were made available to the media by the Department of Justice. And yet she's blaming the Facebook post for all of the media coverage of this case that was engendered by what the Department of Justice did. The publicity from the case and accompanying threats from third parties on social media made her scared for the lives of A and E, those are the foster children, Laurel and herself. Although Aaron Klein has been interviewed by the media on a number of occasions about the case, he did not initiate any contacts with the media. I've read that section before, but it's important to underscore this. Other than posting the complaint on his Facebook page, there is no evidence that Aaron Klein gave complainants' names to the media. That's dispositive of the claim that he doxed this couple. That's a matter of certified fact, for whatever the certification in question might be worth, found here in the final order. I think it's interesting and useful to talk about what this forum, that's how this venue is described in this document, not a court, not a panel. It's described as a forum. And I think that highlights the fact that we're not talking about a legitimate judicial body here. How the forum evaluated the testimony of Laurel, who was the one who filed this complaint. Laurel was a very bitter and angry witness who had a strong tendency to exaggerate and overdramatize events. On cross-examination, she argued repeatedly with respondent's counsel and had to be counseled by the administrative law judge to answer the questions asked of her instead of editorializing about the denial of service and how it affected her. Her testimony was inconsistent in several respects with more credible evidence. Here are a couple of very important examples of what have to be considered perjury, or what would be considered perjury if this had been a real court. She testified that her blood pressure spiked in the hospital to 210/165 on February 1st, 2013, when she learned that her Department of Justice complaint had hit the media requiring the immediate attention of a doctor and 4 nurses. Her treating doctor's report notes that she was upset and crying about her situation hitting the news, but there is no mention of a blood pressure spike. That's perjury. If this had been a real court, she'd be up on charges. She testified that the media were standing outside her and Rachel's apartment on February 1st, 2013, when she talked to Rachel from the hospital. Rachel, who was at the apartment at that time, testified that the media were not outside their apartment at that time. It's another act of perjury. Laurel testified that Rachel stayed in bed the rest of the day after she returned from the cake tasting at Sweetcakes. In contrast, Rachel's younger brother testified that he, Laurel, and Rachel had a 30-minute conversation that evening. The forum has only credited her testimony about media exposure when she testified about specific incidents. The forum has only credited her testimony when it was either A, undisputed, or B, disputed but corroborated by other credible testimony. She's a proven perjurer. Why is her testimony considered credible in any sense? It's because of her identity. It's because she's part of a specially protected class, and because her feelings were hurt, and because she was offering this testimony before an administrative bureaucracy that is acting outside the law in pursuit of a collectivist agenda. What I find to be particularly gratifying in light of the fact that this development is so unexpected is that the Oregonian newspaper, which is a deeply collectivist media organ, has actually criticized the actions of Commissar Avakian and his anti-discrimination Soviet in this case. This is an editorial from July 7th of this year, entitled BOLI's Sweetcakes Judgment Takes Aim at Free Speech. It seemed like just maybe the controversy that began 2.5 years ago when a Gresham bakery refused to make a cake for a lesbian couple's wedding ceremony could be drawing to a close. The refusal by the Christian owners of Sweetcakes by Melissa to make the cake was a cut-and-dried instance of illegal discrimination, delivered with a layer of Leviticus-inspired homophobia on top. By the way, as I've pointed out, refusal of service is not described in the statutes as an act of unlawful discrimination. Refusal to accommodate a customer, that's considered unlawful. But there's nothing in the description of that act that would apply to refusal of a specific service. Be that as it may, I continue. The lesbian couple, Rachel and Laurel Bowman-Cryer, understandably filed a complaint against the bakery with the Bureau of Labor and Industries for breaking the law as a business of public accommodation. Once again, they didn't break the law. The law doesn't say that what they did was illegal. But the final order issued by Labor Commissioner Brad Avakian last week ensures that it is anything but final. In a bewildering order in desperate need of logic and common sense, Avakian not only imposes on the the Kleins a $135,000 judgment, but also basically revokes their right to free speech. After all, when a high-profile opportunity for political grandstanding comes along, why keep it simple? Avakian found that the Bowman Criers deserve $135,000 for their pain and suffering from the cake denial. This award, he clarified, is not a fine or a civil penalty. In fact, Avakian lacks the statutory authority to take that kind of action or even to punish the Kleins for their illegal conduct, BOLI confirmed. But Oregon's top cake crusader is making up for that lack of authority through the only power he does have in a case like this, to order damages for economic loss, of which there was none, or for pain and suffering. Avakian contends that the award is in line with other cases. He footnotes, among others, the 2010 case of Charles Edward Minor, who was ordered to pay a 21-year-old female employee $50,000 for repeatedly sexually harassing her and striking her on the head twice. That's actually felonious assault, but I continue. That's less than the $75,000 judgment for Rachel Bowman Crier and the $60,000 award to Laurel Bowman Crier, who Avakian said deserves less because she was not at the bakery for the cake denial and because her testimony about the effects of the cake denial seemed exaggerated to the administrative law judge. But while the amount is a doozy on its own, there's an even bigger surprise in the order. Avakian reversed the opinion of the administrative law judge who presided over the hearing. Bear in mind, once again, Avakian is not a judge, and decided that Aaron Klein violated Oregon law when he recounted what happened on the day of the incident in an interview with the broadcast reporter. Among other things, Klein recalled in the September 2013 interview that when Rachel Bowman Crier informed him that the cake would be for two brides, he responded by telling her, "We don't do same-sex marriage, same-sex wedding cakes." In Avakian's view, Klein's verbatim recollection wasn't just explaining what happened in the past. Avakian contends his statement was, in essence, an advertisement that his bakery would continue to reject same-sex couples in the future. That, Avakian says, violates an Oregon statute that prohibits broadcasting an intent to discriminate on the basis of sexual orientation. Avakian also found that a note placed on the Klein's shuttered Gresham Bakery similarly violated the law. The note, which articulates the Klein's frustration over the state's actions against them, includes a line that, quote, "This fight is not over." That shows they intend to keep discriminating, Avakian contends. Actually, it doesn't, comments the Oregonian. To most people, the line, "This fight is not over," suggests that their fight is not over. At best, Avakian might be able to argue that it's ambiguous, but as First Amendment lawyer Jack Orchard notes, you don't penalize people for ambiguous speech, especially, he notes, when you have the force of government behind you. No matter how odious the Klein's actions were, and I insert once again, their action was not odious by any definition, they're being penalized for a refusal to act, as if they had an obligation to act. No matter how objectionable their narrow-minded, bigoted, and homophobic views are, Avakian's efforts to infringe on basic free speech rights are even more threatening. No, they're threatening. What the Kleins did and said don't constitute a threat in any sense, but I continue. His final order also demands that the Kleins cease and desist from making similar statements that could be interpreted through the distorted lenses that Avakian appears to wear as a veiled commitment to deny service. When even clear statements of opinion are misinterpreted, the clear message to the Kleins is keep your beliefs to yourself. This is not to minimize in any way the pain and suffering that the Bowman Criers have felt throughout their lives, but much of their pain, as described in the findings, relate to treatment by family members, years of navigating the bigotry of those closest to them, and the media attention associated with the case. Heaping the blame all on the one encounter with Sweetcakes will only fuel the fire consuming any rational debate and do nothing to help Oregonians heal and find common ground. In his order, Avakian insists that this case is not about a wedding cake, and unfortunately for all of us, he has succeeded in making it about so much more. The logic, such as it is, of the social justice warrior perspective here is that until and unless we eradicate every vestige of bigotry in act or speech or in thought, there exists a possibility that the insecurities of the victims will be triggered, which means that nothing less than comprehensive, all-encompassing, government-administered re-education of the public will be suitable in order to create their supposed utopia of egalitarianism and tolerance.